これより分科会領土海洋問題
We would like to start the breakout session, Territorial Maritime Institutions and Challenges to the Rule of Law. This will be moderated by Dr. Shunji Yanai, Judge, International Tribunal for the Law of the Sea. Panelist, Mr. Carpio, Supreme Court of the Philippines, Mr. Michael Green, Senior Vice President of Asia and Japan Chair, CSIS, and Professor Kanehara of Sophia University, and then Ms. Lan-Anh Nguyen from DAV, and Mr. Yanagihara, Professor of Open University of Japan. Please.
Good afternoon, ladies and gentlemen. My name is Shunji Yanai. Thank you very much for your introduction. I'm a judge of the International Tribunal for the Law of the Sea, which is commonly known as ITLOS, which has its seat in Hamburg, Germany. This session is entrusted with the task of discussing territorial maritime issues and challenges to the rule of the sea, rural law, I'm sorry. As I was leaving my apartment this morning, my wife asked me, to whom are you going to speak today? So I said, to my friends of JIA. So she said, you speak to them more than you speak to me. So I said, well, they listen. So I'm very honored and privileged to serve as moderator of this session, rather than moderator, perhaps a timekeeper. And I have 5 very distinguished panelists here. And I would like to give them 10 minutes each for the initial statements. And then I intend to come back to them, and we will have perhaps 15 minutes of discussions among ourselves. So without undue delay, I would like to give the floor to the first speaker, Dr. Green, and I understand he will share his views mainly from the perspective of strategic perspective. Mr. Green, you have the floor.
Thank you. I'm feeling very nervous right now because I'm surrounded by 5 lawyers. My father was a lawyer. Somehow I feel like I did something wrong, and that I'll find out what it is. But I'm going to address the maritime disputes question from a strategic or geopolitical or national security perspective. And from that perspective, international law and a rules-based order is both the objective, the thing we are trying to protect, but it's also a tool in how we respond to a Chinese strategy that has evolved in recent years to one that is broadly recognized as a strategy based on coercion of smaller states in territorial issues. China's maritime strategy has evolved steadily over the decades with an emphasis on near seas defense, far sea protection, and more recently, the maritime forces of the Chinese state and party have been consolidated so that the Coast Guard, the Chinese Coast Guard, is on the Central Military Commission, which means, in effect, that China is able to pursue its objectives in these maritime disputes with a unity of government, bridging military, Coast Guard, economic and diplomatic tools. And the Chinese presence in the East and South China Sea has expanded dramatically and has been viewed by almost every state in the region as increasingly intimidating and deliberately so. Near Japan's Senkaku Islands, Chinese Coast Guard ships now regularly enter 3 times a month, 3 ships, for at least 2 hours, the so-called 3-3-2 pattern. Many of these are former PLA Navy frigates, and the new class of Coast Guard cutters are several times larger, in some cases 10 times larger than Japan's Coast Guard cutters or a typical American or Australian Coast Guard cutter. China's artificial islands in the South China Sea have airfields that allow the entire PLA Air Force inventory to operate, and for China to put tactical air over the entire South China Sea. And recently, Chinese maritime activities in the area of Vietnam and Indonesia lasted for months because they were reinforced and supplied by helicopter from these artificial islands, giving a constant presence. And there's increasing activity under a scientific name for acoustical mapping of the South China Sea for submarine and anti-submarine warfare. It's a very dramatic and very pronounced operational tempo. Japanese scholars began calling this gray zone coercion, I guess about a decade ago or so. Gray zone is a strategic concept that at CSIS we've spent a lot of time studying. And essentially the gray zone strategy is designed to avoid war, but to use coercive tools to force changes in the strategic dynamic. And gray zone activities particularly focus on the seams or the gaps on the other side. So, for example, among the claimants to the East and South China Sea, along the first island chain, there are a number of gaps. In Japan's case, there's a gap between Coast Guard and Navy, MSDF, that gray zone gap. Between the US and Japan, there's a gap because the US does not recognize that the Senkakus are Japanese territory. We recognize the Senkakus are administered by Japan. And so China's persistent presence is designed to call into question Japan's administrative control. It's trying to seek a gap. Between US alliances with Japan, with the Philippines, and our relationship with Vietnam where there's no security commitment, there are big gaps so that China can exploit those gaps. So one way to think of gray zone is an effort to use coercive tools to widen and exploit the gaps among the other claimants to change the balance of power, change the facts at sea or on the ground without conflict. I think we can probably ascribe three objectives to our friends in Beijing here. First, from China's perspective, China is defending what it sees as its territorial claims, clearly. Second, the PLA is pursuing a counter-intervention strategy, is seeking to make it too difficult for the United States to intervene in a conflict in the Taiwan Straits, with the Philippines, or with Japan over Senkakus. And that's why the South China Sea is so important militarily. 20 years ago, a little over 20 years ago, I worked in the Pentagon around the time of the Taiwan missile crisis. Patrick Cronin and I worked together in those days. He'll remember. In '96, the U.S. response to the Taiwan crisis was to send 2 carrier battle groups through the South China Sea near Hainan to get China to back off. Now, if there's a Taiwan crisis, China's strategy will be to surge out of the South China Sea to flank us and make it too hard for us to intervene. That's the military game that's at play. And then the third dimension is, I think, to allow Beijing to dismantle American alliances and commitments by exploiting these seams, demonstrating the Americans can't stop this coercion, and in a more general and geopolitical way, change the strategic dynamics in Asia, weaken the American position, weaken American alliances. Let me briefly conclude, Ambassador, by suggesting 4 areas where the U.S. and Japan, like-minded states, can respond. First, I think the U.S. and allies have a tactical approach we have to take. The Trump administration has increased the number of freedom of navigation operations in the South China Sea and transits in the Taiwan Strait. That is not a strategy, but it's a necessary tactic to demonstrate willpower and to demonstrate the U.S. will not accept coercive efforts to change the status quo. Secondly, there is a legal and diplomatic dimension. The ruling of the Tribunal in 2016, July 2016, should have been an opportunity for the international community to speak with one voice to Beijing about the need to negotiate without coercion on disputes in the South China Sea. Instead, Beijing very successfully bribed Cambodia to block an ASEAN consensus and bribed certain Eastern European countries to block an EU consensus. So in a sense, it was a failure of the use of international institutions and international law because the Chinese side was able to blunt and break up the next step. But it was also a failure by China because I think Chinese intervention in ASEAN and in the EU heightened the alarm within Southeast Asia and Europe. So to me, international law will not solve this in the near term, but it is a tool that will allow greater alignment among different states about the need to convince our friends in Beijing not to use coercive tools. On the military side, a lot of the strategy will have to involve increasing the ability to operate in an environment where there are more threats, more missiles, more submarines, more artificial islands. That is the so-called A2AD environment, and it will mean more standoff strike weapons for Japan, unmanned aerial and undersea vehicles for the US, and maintaining the undersea warfare advantage the US, Japan, Australia, and India all have over the PLA Navy. And then on the strategic side, if the goal that China seeks is to weaken alliances, then the best way to impose a cost in response to coercive measures is to strengthen those alliances. And not only within the bilateral alliances, but to strengthen connections among them, including the US, Japan, and Australia, but also India with the Quad. So we need to think about this strategically. Ultimately, this should be resolved by international law, ultimately. But right now, it's about geopolitics. And before we can get to a place where we have an international legal basis for resolving these disputes, we need to show that power politics don't work. And we still have a lot of homework in that category, I would say.
Thank you very much, Mr. Green, for your statement, and including very interesting 4 points. Now, I give the floor to Justice Carpio. He retired recently from the Supreme Court of the Philippines, and I look forward to his comments from the Philippines perspective. And I just got a bell, and you have 10 minutes. And when you have spoken for 8 minutes, I will ring the bell. So you have the floor, sir.
Thank you. Good afternoon. There are two kinds of disputes in the South China Sea, the territorial dispute and the maritime dispute. The territorial dispute is not governed by any tribunal. There's no tribunal that has jurisdiction over the territorial dispute, and China has refused to submit the territorial dispute to arbitration, so we cannot expect the territorial dispute to be resolved by any international tribunal. The territorial disputes will go on and on until the disputed features are submerged by sea level rise due to global warming. So before the end of the century, the forces of nature will likely resolve many of the territorial disputes in the South China Sea, especially in the Spratlys. In the meantime, to prevent armed conflict in the territorial dispute, China and the ASEAN has been negotiating a code of conduct for the last 17 years, since the signing of the Declaration of Conduct in 2002. The Code of Conduct is intended to manage the dispute to prevent resort to arms. It's not intended to resolve the merits of the claims of the disputant states. However, China has been dragging its feet on the negotiations of the Code of Conduct. China has declared that it will sign a Code of Conduct at the appropriate time when the time is ripe. That means China will sign the Code of Conduct only when all the island buildings in the South China Sea, including on Scarborough Shoal, are completed. When China's completed all its island building, then it will say, let's sign the Code of Conduct, and from now on, nobody builds anything anymore, no reclamation, and that will only legitimize all prior reclamations and island building of China. There are no negotiations, no forum to discuss the merits of the territorial dispute. On the other hand, the maritime dispute is governed by the United Nations Convention on the Law of the Sea, or UNCLOS, since all the disputant states are members of UNCLOS. The maritime dispute between China and the Philippines was resolved with finality last July 12, 2016, when the arbitral tribunal declared that the Philippines is a full 200 nautical mile exclusive economic zone facing the West Philippine Sea, and China's 9-dash line has no effect whatsoever. In fact, the tribunal said China's 9-dash line has no historical basis. In short, the tribunal was saying it's pure fiction. But this 9-dash line is the problem of everybody, the 5 coastal states, Vietnam, Malaysia, Brunei, Indonesia, and the Philippines, because the 9-dash lines encroach on our EEZ. In the case of the Philippines, it encroaches on 80% of our EEZ in the West Philippine Sea. Now, the award of July 12, 2016 is binding only on the Philippines. However, future arbitral tribunal can use that decision, and if Vietnam is thinking of bringing China to an UNCLOS tribunal as it has been considering, then most probably the decision will be the same, that the 9-dash line has no legal effect to claim any part of the waters or resources of the South China Sea. The rule of law in the oceans and seas of our planet is, of course, UNCLOS. And under UNCLOS, coastal states can claim only 3 maritime zones, territorial sea, exclusive economic zone, extended continental shelf, up to 350 nautical miles from the coastline or the baselines. That's the rule. No country can claim beyond 350 nautical miles. China is saying, yes, we have 350 nautical miles under UNCLOS, but we own the rest of the South China Sea because of our historical title, because of history. But the tribunal said that historical claim is totally false. It has no basis at all. Now, since the time of Hugo Grotius is the founder of international law, and he won over John Selden in that famous dispute whether states can own oceans and seas beyond the territorial sea. And Hugo Grotius said, no, states can own only up to the territorial sea. And he won that debate. That's why we have first the 3 nautical mile territorial sea. It became 12. Sovereignty extends to the limit of the 12 nautical mile. Beyond that, belongs the waters belong to mankind, except that under 1982 UNCLOS, coastal states have certain sovereign rights. So the claim of China is really a claim using the argument of John Selden, that a coastal state can own oceans and seas. That's bringing us back to the 1700s, the 1600s, and I think that's bringing back international law to the past. Thus, it is critical to maintain world peace and stability that China should honor the arbitral ruling, should comply with the arbitral ruling. Now, what are the chances of China complying with the arbitral ruling? Will China, a nuclear-armed state, the superpower in our region, comply with an arbitral ruling in favor of a militarily weak state, a non-nuclear armed state like the Philippines? When the ruling came out, a professor from Harvard said, great powers do never comply with rulings of arbitral tribunals. Great powers do as they please. Weak states will suffer what they must. Well, let us look at the historical record. There are 5 cases decided by international tribunals where nuclear-armed states, superpowers, lost to non-nuclear armed states. First is in 1986, the International Court of Justice ruled that the U.S. violated the territorial integrity of Nicaragua when the U.S. mined the harbors of Nicaragua and supplied arms to the Contra. The U.S. said, the ICJ said, the U.S., you violated the territorial integrity, you must pay damages to Nicaragua, and you negotiate with Nicaragua on the amount. The U.S. said, we do not recognize the jurisdiction of the ICJ, we will not comply with that ruling, we have nothing to do with that. So Nicaragua proceeded to establish the amount of damages. While the case was ongoing, the U.S. and Nicaragua came to an agreement. The U.S. would provide economic aid to Nicaragua of about $500 million, provided Nicaragua would withdraw the case in the ICJ. Nicaragua passed a law repealing each law requiring recovering damages from U.S. and withdrew the case at the ICJ. and the U.S. provided economic aid to Nicaragua. The U.S. did not pay damages. It said, no, we don't pay damages. That's admitting wrongdoing. But we give economic aid. So Nicaragua got the money it wanted, but it was not called damages. It was called economic aid. So in my book, that's compliance, because both parties settled their dispute amicably and in accordance with law. Next is the case between Russia and the Netherlands, the Arctic Sunrise case. Russian Coast Guard vessel seized the Arctic Sunrise and its crew because the crew climbed an oil rig of Russia. And the Netherlands sued before ITLOS, and ITLOS told Russia, release the crew and the vessel. And Russia said, no, we will not release. We do not recognize the jurisdiction of ITLOS. But within 30 days, the Russian parliament passed a law allowing Putin to pardon the crew and the crew and to release the vessel. And Putin pardoned and said, we are releasing the crew and releasing the vessel because of Russian law, not because of the ITLOS order. But there was compliance. And then the case proceeded, and the UNCLOS Tribunal awarded about 5.4 million euros to Netherlands for the damage done to the Arctic Sunrise vessel. And Russia said, we will not comply, we will not pay. But last May 2019, the Netherlands and Russia came to an agreement to settle that issue. Russia agreed to pay half of the awarded damages, and the entire case was settled. So there was compliance because Netherlands was satisfied with the arrangement. So here was a nuclear state, the country on earth that has the largest arsenal of nuclear weapons, agreeing to comply with the ruling of the International Tribunal. The next case, 2014 case between Bangladesh and India. India lost. Bangladesh was awarded 4/5 of the disputed area in the Bay of Bengal. And India said, we will comply. And Bangladesh said, we're happy that India readily complied. A nuclear armed state complying with an order in favor of a non-nuclear armed state. The other case is Mauritius versus UK. The International Tribunal said UK violated its obligation under UNCLOS when it declared a marine protected area in the Chagos Archipelago without consulting Mauritius. Mauritius was the former colony of UK, and Chagos would return to Mauritius after a certain period. And the UK said, we will comply. We will comply immediately with the ruling of the arbitral tribunal. A nuclear armed state complying with a ruling that is in favor of a non-nuclear armed state. So we have 4 cases where nuclear armed states, superpowers, lost in international tribunal but complied with a ruling in favor of non-nuclear armed state. There is only one nuclear armed state that has not complied with a ruling of an international tribunal so far. China, when it lost to the Philippines in the July 12, 2016 arbitration. China said, we do not recognize the tribunal's jurisdiction. We will not comply with the ruling. That's just a scrap of paper. But what is happening now? Last November 2018, President Xi Jinping visited Manila, and China and the Philippines signed a memorandum of understanding on cooperation on oil and gas development in the West Philippine Sea. That's the area within our EEZ, but claimed by China under its 9-dash line. And under that MOU, China will participate as a service contractor of the Philippines. And pursuant to that MOU, terms of reference was signed between China and the Philippines to implement the MOU. And last September 2018, when or this year only, 2018, when President Duterte visited Beijing, the members of the steering committee between the 2 states were named. Both parties named their members. And the steering committee met for the first time in Beijing early last month, rather. and they will meet again 2020. So under this MOU, China will get the gas and will be paid for it for providing all the technology, equipment, and services, and the Philippines, for giving the award for the service contract without contributing anything else, will get 60% as owner of the gas. So there is an implied admission by China that the Philippines has sovereign rights over the gas in Reed Bank, because that's the first area. So here we are seeing a possible solution. In fact, when Vietnam and China had that standoff in Vanguard Bank and they met in Beijing, the Chinese told the Vietnamese, why don't you look at the MOU of the Philippines with us? You might want to do that also. So there is a light at the end of the tunnel that China will indirectly comply with the ruling, because in rulings of arbitral tribunals, especially it's adverse to nuclear armed states, powerful states, you cannot expect powerful states to be humiliated. They will comply, but they will comply in their own way. Like Russia will say, we are releasing the crew not because of the order of the ITLOS of the tribunal, but because of our own law. Like the US, we will pay the damages, but we don't call it damages, it's economic aid. So I am seeing the same scenario in the South China Sea. And I will end here, maybe I can discuss later why China has agreed to do this. Thank you.
Thank you very much, Justice Carpio, for his very comprehensive statement, including the very interesting case law concerning nuclear powers. Thank you very much. My next speaker is Dr. Nguyen from Vietnam. I look forward to hearing her views from the Vietnam side. Thank you. Vietnam is also another coastal state bordering the South China Sea. Please.
Thank you very much, Judge Yanai. First of all, I have to correct that I will not speak for Vietnam's government. I will speak based on the jobs has been laid out, that to answer the questions, is it possible to build an international order based on free, fair, and transparent rules in the field of territorial and maritime disputes? And in order to answer the questions, perhaps I think first we would like to look at the cause, the reality, why has it happened. For me, if I look at the situation in the East and South China Sea, there are certain reality that there are numbers of state practice that obviously inconsistent and contradict with the common practice. And I try to categorize them into three categories. The first one, perhaps, what I call is the argument on sovereignty and maritime that based on the ill-found legal basic. Perhaps it will disappoint you, Judge Carpio, because you think that the sovereignty dispute may go away with climate change. But in my research, I found that sovereignty claim even put over submerged features. And also, I found that some argument on history, based on murky history, based on some event that perhaps not really happened in the past. I also found that it's very difficult to understand the legal argument put forward for sovereignty dispute in the East and the South China Sea if we look at from the light of the international law on territorial acquisition that common state practice has been built up. Just name a very specific example. For example, both in the East and the South China Sea, one argument has been made that the sovereignty has been built by the vassal regimes of Ryukyu state, a state that had been no longer exists, and Vietnam. The second category of activity that I find that cause the inconsistent practice in the East and the South China Sea is the generate maritime zone is a generating maritime zone based on the arbitrary interpretation of international law, and sometimes is the intentionally twisting the legal concept. I totally agree with Judge Carpio that come to the field of maritime entitlement, we have all agreed with the legal framework of UNCLOS, whereby we have 5 maritime zones that coastal state can generate from internal water, territorial sea, contiguous zones, exclusive economic zone, and continental shelf. However, when we come to the East and the South China Sea, we can see some different concepts. And I just try to make a contrast between the common legal concept has been well established and accepted, and there's some innovative concept. So first we have historic water has been mentioned in UNCLOS, but then we have another development from historic water, which is historic right and historic territorial sea. Historic right has been mentioned by Judge Carpio, and historic territorial sea has been used to prevent the innocent passage through some features in the South China Sea. We also have the concept of archipelagic baselines that apply to archipelagic state, that the state that constitute only by archipelagos. But then the concept will be applied for mainland, and perhaps from that concept, it built an idea of foreshores in the South China Sea. We also have the concept of historic right that has been recognized by the Tribunal in 2016, but then it developed into exclusive historic zone that may expand to Natuna Islands, that perhaps if we have some Indonesian colleagues here, that they can share with us some of the map that the Indonesian fishermen can find when they have the standoff with some other fishing vessels. They also have, we may be familiar with the concept of sovereign right and jurisdiction over the exclusive economic zones and continental shelf, but then we also have the other concept of sovereign right and jurisdiction over adjacent water and relevant waters. That has been mentioned in the note verbal that China submitted to the Commission on the outer limit of the continental shelf. We also have the idea of exclusive economic zones and then develop into exclusive security zones that has been a legal basis to ignore all the other activities from the third party in the South China Sea, for example. And perhaps another example is also land reclamation, that an activities, that a technique that used to build artificial islands has been interpreted as a friendly, environmental friendly technique, or even like technologies to avoid the damages for the environment when it comes to artificial island building. So there are different understanding, different interpretation that cause the difficulties that we have in reality in the East and the South China Sea. And the third category of activities that I found when I do my research is the double standard. So perhaps it's not always different. And sometimes we have a common interpretation, but just it's come to very convenience for the interest when it comes to one place to the others. So from the East and the South China Sea, we can easily catch some example that we have double standard. The first one we can find is the legal regimes of island and rock. So when it comes to the East China Sea, we have the rock that owned by Japan, for example. The island owned by Japan, for example, become a rock. Whether it's island or rock, of course, is subject to further discussion. But then it comes to the South China Sea, then the features in the South China Sea has been ruled by the tribunal as a rock, but still eligible to generate exclusive economic zone and continental shelf according to China, for example. We have the double standard when it comes to the right of other states. So according to Maliburum, when it comes to the high sea, for example, all the countries have the freedom over the sea and enjoy certain rights. When it comes to the South China Sea, the right of other countries has been excluded. But when Arctic, for example, a country, for example, China, located far away from Arctic, but still claim to enjoy certain right in Arctic. When it comes to sovereignty, for example, we have the problem of the use of force. So actually, in the South China Sea, the use of force has been used twice, in 1974 and 1988. And notably, that is a time that the UN Charter already entered into force and bind upon the member state. But when it comes to the East China Sea, for example, the date of 1895, for example, when Japan and China enter into treaty, has been claimed that it's the illegal use of force that lead to coercion of treaty, that lead to certain sovereignty dispute. And notably, again, that time, even the Charter of the League of Nations hasn't come into force yet. So the use of force still not forbiddable means to claim sovereignty. We also have the point difference come to the dispute settlement mechanism when it happened to WTO or it happened to ICJ and it lost. So with that three category, I can point out the cause that happened at the moment that caused inconsistent in application of international law in the East and the South China Sea. I will leave the way forward, how we come from this to propose a solution in the second round. Thank you.
Thank you very much, Dr. Nguyen, for keeping the time. Now I give the floor to Professor Kanehara. I'm sorry, Professor Yanagihara. And he will discuss the Japanese positions on certain areas of territory and maritime zones. Professor Kanehara. Yanagihara. Sorry.
Thank you very much, Ambassador Yanai. 聴衆の皆さんのですね、9割
Well, over 90% of the audience is Japanese, so let me now switch to the Japanese. So could you please refer to the translation? I am the specialist of international law, at the same time a historian as well. So in the last 2 decades or so, that I was involved in the Japanese territorial issues, including the Senkaku Island and so on. So from my standpoint, that as much as possible, objective historical facts and material must be collected first. And then to do that, not in Japan alone, but globally, I visited, of course, the different material libraries and so on. I obtained the raw, the primary materials. And then according to the international law, I needed to interpret and analyze those materials. So the international law might be different according to the region or the times. What's the concept of territory? That was defined by the modern European international law. So there was no such thing in Japan and China at that time. And that the European concept was retroactively applied to make judgment. However, that will induce misunderstanding. That's my first point. So I prepared 3 issues, but I only have 10 minutes or less. So I'd like to only touch upon a part, some part of what I prepared. So this is the issue that Japan faces right now, the territorial issue. For example, these Kurile Islands and Takeshima, Pinnacle, and then Liancourt. I'd say it's a territorial issue. However, according to international law, is it really a dispute or not? That is a major problem, whether that is really a dispute. In case of the Northern Islands, Russia and Japan both agree that there is a dispute. In terms of Takeshima and Dokdo, 2 islands, Japan advocate that there is a dispute, but Korea denied that. So anyway, about the Senkaku Island, Japan believes that there's no dispute problem because it's clear Senkaku is a part of Japanese territory. On the other hand, China refutes that there is a dispute. That's China's standpoint. So this is the Northern Islands. And this is the Takeshima Dokdo, and this is the Senkaku Island. So the details I will skip because if you have a particular question, let me ask this is a map that you might not have seen much before. There are 4 ways or 4 gates that we have identified. During the Edo period, Japan was supposed to be closed down. Lots of people learned that Japan was diplomatically closed, but that was not really the case. Japan was open to the rest of the world in certain areas. So these 4 gates actually demonstrate. Matsumai Gate is one of them, open to Ezo, the Hokkaido, north. Tsushima Gate, Japan was open to Korea. And Deshima Gate opened Japan to the Dutch and the Chinese merchants. And the Ryukyu Gate opened Japan to the Kingdom of Ryukyu, to the south. So at that time, Japan was supposed to be the well, we didn't have that modern the international law term of territory, but we used the word hanto at that time. What is hanto versus the other place outside the hanto? That is called the kegai, outside that, the jurisdiction. Hanto is an old Chinese word. And maybe Japan used the word different from the Chinese interpretation. That is a point of caution. In the recent, modern international law, the word territory is translated as ryoiki in Japanese word. This is a coined word here in Japan. It's a coined word here in Japan, ryoiki, the territory. But the word started to be used in 1890s and afterwards. So before that, it just was called hanto, and many other words were used to mean the territory. And in the meantime, another interesting thing is in 1871, the Sino-Japanese Amity Treaty was agreed. In the Article 1, it talks about the territorial possession of either country. So the Japanese translation was the hodo at that time, meaning territory. Hodo. But Japanese side consider that as a European sense of territory, but the Chinese interpreted it differently. It's not territory, but it's the Chinese traditional concept of the hodo. So it's the same, the treaty signed by 2 countries used the same word, but Japanese interpretation was different from that then the Chinese kingdom, the Chinese China. So that later on linked to induce many other problems. And in 1976, Honchan Lee and the Japanese Tribunal Mori had a meeting, and then in that meeting as well, the difference was clarified. And then so Okinawa?
の口で
I told there were 4 gates, and one of them was Ryukyu Gate. Kingdom of Ryukyu was it a hanto of Japan, territory of Japan or not? Back then, in Edo period, Kingdom of Ryukyu was not inside the Japanese hanto or territory. In my view, that was the case. But what was this Kingdom of Ryukyu? About this positioning, among the historians, there are divergent views. The Meiji government, when they tried to cope with this Kingdom of Ryukyu, there was this very ambiguous attitude on the part of the government. In 1872 September, Meiji government made it clear that the kingdom is a part of hanto and territory in the modern international law. And for this Ryukyu disposal, Ryukyu was incorporated into Japan, and China vehemently opposed against it, and the negotiations between Japan and Qing dynasty didn't go well. And then the former president, U.S. President Grant, he was asked to serve as the arbitrator. And he came up with these 3 divisions as proposal. This is the 3-way proposal. There are 2 lines, 25 degrees north, 27 degrees south. 25 degrees below, that's China, and 27 degrees and upward to the north, that's Japanese territory, and somewhere between these 2 lines, Kingdom of Ryukyu. That was his proposal. neither Japan and China, a kingdom of Ryukyu, opposed, didn't agree. So Japan made up with this two-division proposal, division of islands. Well, according to Japanese version, didn't specify the degrees, but Miyako and Yaeyama belong to China, but all the other Ryukyu area should belong to Japan. That was the Japanese proposal. Qin dynasty, the negotiator, agreed to this proposal by Japan, but the mainland ultimately opposed against this plan, so this plan did not come through. So between these two countries, it was left untouched without any negotiation. So a de facto recognition of the Japanese way of handling Ryukyu kingdom was accepted. In the Shimonoseki Treaty, there was no negotiation on this particular topic. And here, Senkaku Island is here, included here, in the northern latitude 25 degrees, a little north of 25 degrees, latitude north. Up until 1881, there was a negotiation between Japan and Qing. There was no reference to Senkaku. I have checked various old documents. I haven't found anything. Japan didn't make any claim, neither Qin dynasty. So back then in the negotiations, Senkaku was not thought of at all. That's how I view this. There are 36 islands in Ryukyu. It is said among these 36 islands, Senkaku Islands were not included. It's so clear. In history, 1880s, mid-1880s, the Senkaku started to pop up. I have 2 more minutes. So, the second issue, the rule of law in the international community. There are so many things I would like to say, but I just skip this. Please take a look at this. Brierly, J.L. Brierly, is the professor of the laws in the Oxford University. The Law of Nations was established in 1928. It's written in English, and this is one of the greatest textbook of international law in English in the 20th century, in my view. The Law of Nations is neither a chimera nor a panacea, but just one institution among others which we have at our disposal for the building up of a saner international order. It is foolish to underestimate either the services that it is rendering today or the need for its improvement and extension. That's what the Law of the Nations said. It was written more than 90 years ago, but this idea or concept still holds, in my view. Chimera is in the Greek mythology. It's a imaginary creature, and the equivalent in Japan would be nue, in my view. International law is not a chimera or nue, which is imaginary. International law exists, but it's not a panacea either. You cannot overly depend on international law, but you should not underestimate international law either. So the international laws as we see now, how can you improve and expand the international laws? That's more important. It shouldn't be done unilaterally or by the use of force. It should be done in a peaceful manner. That's so important. More than 90 years ago, Professor Brierly just advocated this wonderful idea. Thank you.
Professor Yanagihara, for his very interesting presentation, including the story on Khmer. My last speaker is Professor Kanehara, and she will discuss the rule of law as the diplomatic policy of Japan. Please.
Thank you very much, Judge Yanai, for your very kind introduction of me. It is a great honor for me to make a brief comment on this occasion. Next slide, please. I will speak about the rule of law in the East and South China Seas from the perspective of the law of the sea. As to the rule of law, please look at the slide. You can find 3 principles. I will take up these 3 points in this order. First, any rights should have their ground in law. International law mainly takes the forms of treaties and customary laws. Regarding the law of the sea, the United Nations Convention on the Law of the Sea, UNCLOS, is the most important treaty. In parallel, customary laws traditionally have played indispensable function. As worldwide known, China has claimed its historic right in the South China Sea to encircle extravagantly wide sea areas by the so-called 9-dash line. It was clearly denied by the arbitral tribunal in the famous South China Sea case. In this regard, very importantly, China has emphasized customary international law as the legal ground of its historic right. This has both positive and negative aspects for the rule of law. The positive aspect: China clearly recognizes the necessity for its historic right to be based upon customary international law. China seems to admit the role of the international law for the justification of its historic right. The negative aspect: China abuses the customary law. Such customary law as that China insists has not been established. Thus, China cannot find legal justification of its historic right in international law. Beyond abuse, not to mention, states are not allowed to change international law by force. This is the second principle of the rule of law. International law, by its fundamental principle, prohibits the use of force and the threat by force. Article 2, Paragraph 4 of the United Nations Charter provides for it. Nonetheless, it is very difficult to precisely define the meanings of the use of force and the threat by force. Therefore, here, in place of defining the
ように意味を定義する代わりに見てみたいのは具体的な点です。実際何が東、そして南シナ海で
As a framework, Dr. Nguyen already gave us the sketch of state practice of the East and South China Seas. China has frequently dispatched its Coast Guard vessels to the territorial seas of neighboring states. The Coast Guard vessels have been recently incorporated into Chinese military under that country's legal system. Chinese fishing boats have also come to the territorial seas of neighboring states, and in some cases, with escort by China's Coast Guard vessels. The Chinese fishermen suddenly become militias, civil soldiers. Even China's military vessels also enter territorial seas of other countries. In addition, China has constructed military facilities on the islands over which other countries have claimed sovereignty. Are these acts by China regarded as the use of force and/or the threat by force? In reality, as a matter of fact, nobody denies that these Chinese strategies of making use of its Coast Guard vessels and fishermen as civil soldiers, and even its military vessels, have posed serious threats on the neighboring states. The tense situation are produced by China in the East and South China Seas. Mr. Green spoke about strategy as to how to cope with China. In sum, I strongly believe, and I can safely say that those Chinese strategies are regarded as use of forcible measures. This is so in considering the actual threats posed by China on Japan and South Asian countries. Those Chinese acts have been conducted for the purpose of overt demonstration of its sovereignty over the territorial seas and the islands, in contradiction to the claims of sovereignty by other states. Thus, by using forcible measures, China is changing status quo and even challenging the relevant international law. The dispute regarding territorial and maritime sovereignty should be peacefully resolved. Here comes the third principle of the rule of law. There are various ways of dispute settlement for state-to-state disputes. As for non-judicial means, there are such as negotiation, mediation, conciliation. As for judicial means, states can use arbitral tribunals and courts of justice, such as the International Court of Justice, ICJ, in The Hague, and the International Tribunal for the Law of the Sea, ITROS, in Hamburg. Among these various means, it cannot be denied that there has been a preference among Asian countries of non-arbitral/judicial procedures. Professor Yanagihara explained the Asian perspective toward international law with Western origin. Nevertheless, recently, we can count several cases that were entertained by the arbitral and judicial procedures, namely by the ICJ, the ITROS, and arbitral tribunals. Judge Carpio raised some cases. Not to mention the South China Sea case is the typical example. Japan, thus far, has offered 3 times judicial settlement of the territorial disputes with Korea. Considering this recent tendency among Asian states, I will focus on the significant merit of the arbitral/judicial procedure from the perspective of the law of the sea. It is the declaration of international law which universally applies to all the states. In comparison, by non-judicial means of dispute settlement, particularly by negotiation, the focus is principally placed on the special situations that exist only between the party states to the dispute concerned. In arbitral/judicial procedures, in order to resolve disputes, international law is applied. Arbitral tribunals and judicial courts declare international law and provide the authoritative interpretation of it. I have to immediately add that in declaring and applying international law, both arbitral tribunals and the judicial courts never exclude indispensable consideration of the particular situation in each case. Then, why the declaration of international law is significant from the perspective of the law of the sea? This is because all the maritime issues have general implication for the states in the world. Even resolution of bilateral disputes and the treatment of regional maritime issues have impact on other states worldwide. In this regard, it is important to exactly understand that the seas entirely cover our globe as a whole, and that in every part of it, sea areas, various uses of sea by many states are taking place at the same time. Therefore, in establishing the regional code of conduct for the South China Sea, exclusion of any states should not be allowed. Non-South Asian countries, including the US and Japan, are also the substantial stakeholders in terms of navigation of the sea areas. Thus, maritime issues, even bilateral and regional, raise global concern. This is the very reason why here we get together for the global dialogue with respect to the rule of law for maritime issues. Thank you.
I thank Professor Kanehara for her very clear analysis, including some suggestion for the solution of disputes. Now we are at the second round, and I realize that my neighbor, Mr. Green, is a fluent Japanese speaker. So I want to switch from English to Japanese. どうもありがとうございました、皆様。
Thank you very much, everyone. Thanks to your input. Now, we have the comprehensive the picture in our mind as to this problem, an issue. We have about 15 minutes left to have the panel discussion further on this matter, especially
for this territory and maritime issues. How can we peacefully resolve the disputes? I would like to hear recommendations, suggestions from the distinguished panelists. I work at the ITLOS, and I saw many disputes. Judge Carpio talked about Arctic Sunrise case between Russia and the Netherlands. At that time, I was the chief judge. As an interim measure, there was this, but I gave an order to release immediately, and Russia didn't come to the court to start with. As Judge Carpio said earlier, actually, Russia complied, de facto compliance. Russia came to the court in 3 cases, didn't come to the court in 2 cases. There was this Russia capturing Ukraine military vessel. At that time, Russia didn't come to the court. And ITLOS made the order to release the military vessel immediately. Russia didn't comply. But recently, they did, both the vessels and the crew. So allow me to say a few words of my own. In order to solve disputes, negotiations, arbitrations, those are the ones who will bring non-binding solutions. But if it doesn't solve, there should be a court case to solve the issue. But it is not so now. International trial cannot start without the agreement on both parties. An exception is there that the one party can bring the case to the court, but that's an exception. But going forward, whatever the dispute is, if the negotiation doesn't conclude that or resolve that, it should come to the court, end up in court, but it will take time. UNCLOS said so. There are 3 different types of courts the UNCLOS can use: ITLOS, ICJ, and arbitration court. At least, be it ICJ or ITLOS, if the parties do not choose either ITLOS or ICJ, it should at least go to arbitration. But other conventions do not stipulate that. So in reality, among different treaties, when establishing, formulating the dispute settlement clause, it should be a clear indication that the dispute should be solved by court. Now, second round. I would like to start with Mr. Green. If you could suggest any solutions.
Well, in my opening comments, I made some reference to the general strategy the U.S. and Japan, Australia, India, and others should take to counter gray zone coercion and create a better geopolitical environment for rule of law. But let me go one step further and describe what that scenario could look like, inspired by Justice Carpio's really fascinating jurisprudence history. An outcome where we return to the status quo ante, it would be desirable but is unrealistic. I don't see Beijing ordering that these islands be dismantled and the coral put back. But a more realistic outcome might look like this. First of all, the PLA and Chinese Coast Guard operational tempo in the East China Sea and the South China Sea goes down. Second, in the Code of Conduct negotiations, Beijing stops pressuring Vietnam or the Philippines or other countries to agree to a clause banning the U.S. or Japan or other countries from operating militarily in the South China Sea. Number 3, China announces that it is not going to declare an air defense identification zone over the South China Sea. Number 4, China makes no move to create a 4th runway on Scarborough Shoals, which, as Justice Carpio, I think, suggested, would be an extremely provocative next step. Number 5, Beijing and Manila begin negotiating some joint fishery arrangement, because our understanding at CSIS, based on our satellite imagery, is that Philippine fishermen are not able to fish in Scarborough Shoals, where they fished for centuries. Japan has successfully, in the past, negotiated joint fishery agreements in disputed territories with Korea and with Russia. So a Chinese-Philippine agreement like that would be an important confidence-building measure. Number 5, the joint development model that Justice Carpio described between Manila and Beijing can be successfully adopted by Vietnam and other countries. However, I'm somewhat skeptical about that because of Japan's experience with China on joint development MOUs, which eventually collapsed. So I wish you luck. But experience creates some skepticism. A good outcome would be that you're successful, and maybe Vietnam can look at this more seriously than right now. I forgot what number I'm on because I put ticks instead of numbers. I think I'm, thank you, 6, taking notes. Number 6, you may have heard of QES, the agreement among all the navies in this region about incidents at sea. The PLA Navy and Coast Guard considers those irrelevant in the South China Sea because they claim it's not international. But if we had QS or Coast Guard agreements, confidence building measures, that would be an important step forward to avoid accidents. Finally, Beijing finds a face-saving way as the fifth nuclear power to begin complying with the tribunal ruling. I think for all of these things to happen, the United States and Japan, India, Australia, bigger countries are going to have to back ASEAN and support ASEAN in every way possible. I think the US, Japan, Australia, but also Britain, France, are going to need to continue doing operations, joint exercises to demonstrate that we will not be intimidated. And finally, I think that we need to continue making the arguments that we've heard from my other panelists about international law. Winston Churchill said, jaw, 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 meaning talking. Jaw, jaw, jaw is better than war, war, war. Sounds better with a British accent. His point was right. There will be huge disagreements about these points of international law. But if those are the actual disagreements, that's enormous progress.
どうもありがとうございました。こんな多分10点ぐらい。
Thank you very much. You have come up with 10 points of recommendations, quite useful.
Very much. Justice Carpio, please.
Thank you, Judge Yanai. I have this proposal. For the territorial dispute, the claimant states can declare the area in the Spratlys as a marine protected area and suspend their territorial claims for the next 50 to 100 years. I think the Philippines is prepared for that. I think Vietnam is prepared for that, Malaysia and Brunei and even Indonesia. But the biggest beneficiary really is China if the Spratlys are declared a marine protected area, because today China is taking over 50% of the annual fish catch in the South China Sea. In the 1990s, China was taking only 20%. But China is becoming a rich country, and therefore its people want fish on the table. And their coastal waters are already polluted, so they have to fish outside of their own exclusive economic zone. That's why they are entering our exclusive economic zones already. So, and you need the Spratlys as the breeding ground for fish. Without the Spratlys, you will not get fish, as much fish as you get now in the South China Sea, because the Spratlys are where the fish spawn. And the currents and the waves carry the egg and larvae to the coast of China, Vietnam, Malaysia, Brunei, Indonesia, and Philippines. So we really need to preserve the Spratlys as a breeding ground. And the South China is the most productive sea in terms of fish. It's because of the Spratlys. So we have to convince the Chinese people, since you want fish on your table, and you're taking now most of the fish in the South China Sea, why don't we preserve the Spratlys as a marine protected area, suspend territorial claims for the next 100 years, and only Coast Guard vessels. No military facilities in the Spratlys. If you have military facilities now, convert them to marine research centers or ecotourism places. And in that way, we reduce the tension. So that's my proposal for the territorial dispute. Maritime dispute, we are, in the words of our Foreign Secretary Locsin, he said, we are almost there. He was referring to the MOUTOR and the negotiations to form the steering committee. And we are at the last phase already. If there's an agreement between Sinuk and Forum Energy, Sinuk is the Chinese commercial enterprise state-owned that does gas and oil operations. If there's a commercial agreement, then we have found the formula. And this is applicable throughout the South China Sea. And in that case, it will be a soft landing for China. How will China explain it to its people? China will say to its people, we have settled our maritime dispute with our ASEAN neighbors. We are very generous. We're giving them 60% of the oil and gas. We will get only 40%, but that's okay because we are the big brother. And they will continue with their narrative that they have been generous when they settle their territorial boundaries with other states. So But why is China doing this really? Why is China sadly agreeing to the MOU? One, I think, the arbitral ruling is a great wall that prevents China from breaching the 350 nautical mile allowed by them under UNCLOS. The great wall now that prevents China from claiming the rest of the South China Sea is the arbitral ruling, because there is no government in Vietnam, Malaysia, Brunei, Indonesia, and the Philippines that's willing to concede sovereign rights to China. With that ruling, we know we have the rights. We have the exclusive zone. And the people will be angry, will overthrow any government that cedes sovereign rights to China. So China realizes this. And second, the foreign naval powers, US, UK, France, Japan, Australia, India, Canada, they all sail in the South China Sea every day. And when they sail, they say, there are high seas here in the middle of the South China Sea, about 25% of the South China Sea high seas. We can sail here, we can conduct military activities, we can have live firing. And in the West Philippine Sea, this is an exclusive economic zone. Under UNCLOS, there's freedom of navigation and overflight. We can conduct naval drills. So these naval operations actually refute China's claim that everything within the 9-dash line belongs to China. So there is actually enforcement of the ruling, very robust. And China cannot stop this anymore because the ruling is there, and all these naval powers are using the ruling to justify their presence in our EEZ, to conduct military activities, and China cannot do anything. Third, China has a trade war with the US, and they have to settle some of their disputes. They have massive protests in Hong Kong. Fourth, the Maritime Belt and Road Initiative of China starts in the South China Sea. And all the coastal states along the way will not believe in a peaceful China if China is grabbing the exclusive economic zones of 5 coastal states. If China has a dispute with 5 coastal states in the South China Sea, nobody will believe that this Maritime Belt and Road Initiative is a peaceful initiative. So China has to settle with us. So I think we are at that moment now. Of course, I cannot guarantee that China will not walk away and say, sorry, we will not push through with the MOU and TOR. But I think there are powerful incentives for China to come to an agreement with us without China losing face. So we're trying to help China settle this by agreeing to a soft landing for China. We will go do this through a service contract. China gets 40%, which is what other companies, Western companies, get when they do oil and gas development in our exclusive economic zone. So thank you.
どうもありがとうございました。
Thank you very much for a very specific and constructive the soft landing proposal or the way of case. Maybe Ms. Nguyen, please.
Some proposals. So the first proposal will target to the sovereignty dispute. I totally agree with you that perhaps an environment protected area would be a good way to frozen the sovereignty for a certain year. But in order to do that, or in order to give more incentives for the country to do that, there is another additional method that perhaps most of the sovereignty dispute related to history, and there more than one history has been sharing. Most of the time, we just listen to the history from one party, and that party would believe that the only history. But then we have France, we have the US, we have Japan, we have the UK, and some other countries have the historical record about the regions. And if we can come up with sharing the historical record on history of the region at a certain moment of the dispute, then it may help to have the objective pictures on what have been happened. And by that, we can have more objective pictures about the dispute and give more incentive for China to come forward to a more comprehensive idea about the dispute. The second solution that I would like to rely on is diplomacy. I agree with Michael Green that really we need the coalitions between the like-minded countries in the regions. perhaps if one of the most effective ways to address the gray zone to not just collision in general, but collision in the rules of law, because we have a new situation happen in reality, so we need a new rule to adapt to address with that scenario. And luckily, so far at the moment, no party accept that they are violate the rule of law. They always say that they still comply with the rule of law, just in different way of interpretation. So the way forward for the country to encourage a common interpretation of the rule of law is to apply the rule of law in common state practice and to voice up when they see the inconsistent state practice. Because in the rules of law, if we keep silent, it means acquiesce. That means we agree with that I have done, and in that way encourage the inconsistent practice. The third matter that I think of is try to make more or costs on enforcement. If any one of you attend the previous panel on China, I have been impressed by the presentation made by Professor Sheng Li when he discussed why the world has been successfully persuaded North Korea to comply with certain methods raised by the US and other countries because of the sanction, because of the cost that North Korea face when they violate international law. So perhaps nothing free in this world. We need to accept certain costs in order to have a rules-based order. And that cost, of course, not bear only upon one party. It bear upon us as a whole. But if that cost will have to bring up, to uphold the rules of law, then perhaps it's worth to consider. And how to discuss in detail about the cost, of course, is another story. I will not try to jump into details, but trade war, what happened to Huawei, what happened to different methods that we see in the war between the US and China at the moment, perhaps give us some idea of what the community can do if, in the worst case, they need to increase the enforcement. So H, history, perhaps just stand for hope. And diplomacy perhaps needs more decisive action. But enforcement is the most important, because at the end of the day, I agree with Dr. Green that judicial mechanism, it will be the most objective method to help settle the dispute. But we have the ruling. It doesn't mean anything if we cannot enforce. We can enforce in the way that state fits saving, like Judge Carpio proposed. But in order to have it in that way, still the party need to see what if they can easily walk away without any cost, without any enforcement. So perhaps it just stands for deterrence, but it would to have a consideration in the mechanism, because at the moment, the rule of law have the biggest weaknesses of no enforcement, no effective enforcement mechanism. Thank you.
どうもありがとうございました。大変重要な発言が
Thank you very much. We have listened to so many important comments. I didn't interrupt them because of the importance of what they were saying. We have only 3 minutes left. If I can extend a bit and give you each 2 minutes, and then we can take one question from the floor. Yes, please. Allow me to say 2 things. One, in 2008, on the 18th of June, between Japan and China, concerning East China Sea, there was an agreement on gas field. Article 74 of the UNCLOS, there's an interim arrangement. And I thought that was an epoch-making move, and I wrote an article on the Asahi newspaper. That was a victory of Japan, but things stopped moving. Should be this is an interim measure. Should be finalized in treaty, and China did not dismiss or negate the interim agreement. So we should make efforts to bring it up to the treaty when President Xi comes to Japan, and if we can make a progress at that time, that would be wonderful. Second, the dispute. How can we solve disputes? That can be solved at court. That's the best way. But in order to bring it to the court, there should be a dispute in existence. How can you define dispute? This is one big challenge in the international law. In 1950s, ICJ made the ruling. Whether there's a dispute or not, it's an objective determination, it said. What does this mean? It doesn't mean anything. Sorry to say this. In 2016, ICJ ruling, another ICJ ruling, Marshall Islands, there was an accident or incident. The claim, whether your claim is positively refuted or not, is there recognition to that? So there was a ruling to that effect. But does this carry any meaning? I said improvement of international law is needed earlier. But whether this ruling is the improvement or not, I'm not quite sure. Thank you. Professor Kanehara.
I would emphasize the necessity of various, or I might say different viewpoints in assessing international order, which is the keyword of this Tokyo Global Dialogue. Otherwise, we would lose sight of the function and even the existence of international law. International law does not have any authoritative legislative, executive, and judicial organs. It is totally different from domestic laws. International law lacks forcible executive measures and compulsory judicial procedures. For this reason, it seems to be a weak law. But in place of these measures and procedures, in the international society, we can find a different function of international law. It is the function to justify states' acts. As explained in my brief comment, China seeks legal justification by international law for its historic rights on the one hand. On the other hand, other states in the world have criticized Chinese acts by referring to the legal binding decision rendered by the Arbitral Tribunal in the South China Sea case. The worldwide criticism can make serious disinterest to target the states. The disinterest can produce unavoidable pressure on target states to abide by international law. Thus, although international law and decisions by tribunals cannot be forcibly executed, as the justification or non-justification standards for states' acts, international law is meaningfully working. International society needs perfectly concerted actions to form the strongest one voice. In this regard, Judge Yanai introduced examples of Russia that finally realized what the court ordered. In order to clearly recognize this special function of international law, we need to have inherent viewpoints in precisely assessing its role and function. Otherwise, we would lose sight of its function and even its existence. Thank you.
Thank you very much. I'm sorry to rush you at the very end. 3 more minutes, sorry. And I see someone at the front. I listened to what Judge Yanai had to say. I learned a lot. You talked about South China Sea. I am from China. I'm from the Social and Science Academy. For the South China Sea case, I have my personal view I would like to share with you now. The Chinese attitude I am sure all of you already know. So this is my personal view. There are three things. To be sure, UNCLOS is the law for the maritime issues. Well, there are certain things that the UNCLOS doesn't cover, and other international laws have to cover that area. Second, between China and the Philippines, is there a real dispute in existence or not? The Philippines may want to bring it to court, to the arbitration court. But if it wants to do that, would the Philippines' claim satisfy all the preconditions? 3, China is not solving based on law. There are 3 stages, 3 attitudes on the part of China. 1, they would like to resort to political solution. Second, if the political solution doesn't solve the problem, crisis management framework is used. 3, joint development. And the final conclusion, a resolution. Thank you. Thank you very much. I have heard your opinion. One thing I would like to make clear. South China Sea's ruling, it is not coming from ITLOS. China did not designate the arbitrator as a judge. So on behalf of that, I made the ruling. Whether there was a dispute or not, what kind of laws to be applied, the conclusion came from the PCA. So for more specific issues beyond that, I refrain myself from answering or making any comments. Thank you very much for your participation today. And I would like to thank the audience as well.
皆様ありがとうございました。この後間もなく法王の間におきましてラップアップセッションを開催いたします。お席をお立ちの際は
Please move to this whole room, and then please make sure that you leave the translation receiver on your table. Thank you for your cooperation. Soon the main plenary will start in the whole room next to this.